first question is, let's say we have a contract, a reinsurance contract, and it has an ECO or an XPL clause, but it does not specify whether or not it covers punitive damages or not. And how do you think that particular clause applies in the case of a punitive damage award there?
I think that you start out with the analysis from the perspective of understanding that reinsurance contracts would be interpreted or analyzed by a court the same way any other contract is analyzed, and that is the court is going to look to the four corners of the document first to try to evaluate what the parties intended, and that's usually expressed through the language of the contract. If you've got ECO, XPL language, but it doesn't expressly say punitive damages, the court's going to have to look at the entirety of the document to evaluate whether there's going to be coverage for that particular situation. You're going to have a whole series of arguments around that, including the issue of whether punitive damages are insurable in the particular state that you're in at the time, and whether you and if it's an old contract, if it's a contract of reinsurance that was written in the 50s or 60s or 70s, and it's being interpreted today, then you've got the added layer of headache to have to go back and try to tell the court, well, you have to put yourself in the seat that the parties were in when the contract was signed. What was the law at the time? What were people thinking about at the time? And how is that intent expressed in the language of the document in front of you? Other places to look in the contract to help would be the definition of ultimate net loss or loss, and then what follow language there is in the reinsurance contract, and is it a treaty or is it a fact cert, which could have some effect on how the court would interpret it. And I think one point that I wanted to touch on that Chris made in one of the slides is the context of whether you're in court or you're before an arbitration panel. And I really think that drives so much of how these issues get played out, because when you're in a court, you're almost certainly going to be dealing with a decision maker who has very little specific industry understanding or background. So what you present to the judge in the way of other cases is going to be very persuasive. Whereas if you're sitting in front of a panel of three industry experts, their viewpoints about it are going to be markedly different. And even if you present law, and even if the panel is somehow allowed to or even instructed to look at the law, it's not necessarily going to carry the day. So then you're really going back to an industry custom and practice assessment.